Next up, we've got Richard Leedham to talk about trial.
Good morning, everyone. My name's Richard Leedham. I'm a partner in the litigation group. In similarity with John, my day job is really insurance litigation, acting for large corporates, but I dabble in fraud. And for the last 18 months, with John, Ian, various others in the room, Clarissa, Lara, Nikita, we've been acting for an alleged fraudster on the other side of this particular scenario, perhaps on the other side of many of you in the room. So I've sort of seen things from a slightly different perspective. I'm going to talk a couple of minutes about trials. Trials are almost by definition, dependent on the facts of a particular case. It's very hard to give overview advice what to do. But just picking up Mark's theme, and without stating the obvious, a room full of well-educated people, so preparation is key to all of this. As you get towards the trial, work out who you need there, have you got your witnesses lined up, and I'll come back to them in a minute. What experts you need. You've heard a lot from us today about different steps that are taken along the way, and a lot of that is in conjunction with other people. So if you've got your forensic experts lined up, do you need valuation experts, the value of the assets? Do you need experts on foreign law if there are issues going on in other jurisdictions? The English court very adept at hearing foreign lawyers give evidence. Do you need handwriting experts? Very often fraud cases will turn on documents, as we'll come on to see, and there'll be allegations about documents being backdated, not being signed by the right people. Get all those experts lined up, and the thing not to ignore is the basics. Are they going to be ready for the trial? When you get your trial date, make sure your witnesses are aware of it. The worst thing that can happen in many ways is people who have been lined up on the case for years sometimes can't make the actual trial. The commercial court where the case will be heard, very sophisticated. The Rolls building, the new building off Fetter Lane, has had a bit of criticism. In some ways, could be better, but is pretty up to date in terms of technology. Again, because of the foreign aspects of lots of cases and the unwillingness of people to come to this jurisdiction or to leave the jurisdiction they're in. Excuse me. Very often, evidence is given by video link. There was some of you might have followed the Cherny-Deripaska trial. Mr. Cherny won't leave Israel. He gave his evidence in that case by video link from Israel. There's a procedure in the CPR that covers all of that. But I think the key thing to just turn it into a little bit of personal experience here is your witnesses. You're not allowed to train your witnesses, but you can prepare them, and there are people, service providers who help that. We have we're fortunate to have based in our Leeds office, we have a team that actually does health and safety prosecution work, and Mike Elliker is in court, often in the criminal context all of the time, and he's very good at talking to witnesses. Very often it's where you're on the side of the claimant, you've got witnesses who may well not have given evidence in court before. Don't underestimate how they might collapse near to the trial. We'll need a bit of encouragement. We'll need to have it explained to them the court process and how, frankly, adversarial and unpleasant it can be when you're being cross-examined by highly skilled individuals who are trying to trip you up. And I think that the key to it that's borne out by the case I'll take you to is all the things that we as lawyers say to our clients, and sometimes you think, well, it's not really legal advice, it's just common sense. They are the things that determine whether your witnesses come across as credible and winning the case, being clear, being truthful, and answering the questions. Because in fraud cases, probably more than any other cases, that's what the evidence is about. What one side will be saying, typically the alleged fraudsters will be saying all sorts of things, but a common theme will be, well, the company knew all about this, I didn't do it, that document doesn't mean what it says, and very often the documentation won't be particularly clear. On the company side, there's also the temptation to take the sort of righteous path of, we knew nothing about this, the company is fantastic, it's nothing to do with us. So in the case that many of us have been involved in, although our client declined to appear at the trial, let's leave it like that for now, but the trial proceeded without him as the main defendant. It's a alleged banking fraud case. Just reading from the judgment, firstly what the judge said about the bank's witnesses, and bearing in mind a lot of the witnesses were foreign. The case was all to do with a Kazakh bank. One witness, he gave his evidence in English in a clear and confident manner. Next witness, he gave his evidence with clarity and fairness. Next witness, Mrs. Alinbatova gave evidence in Russian to an interpreter that she had some command of the English language. She gave her evidence in a clear and intelligent manner. She did not hesitate in her answers, save when the passage of time from the events in question meant she had and could not be expected to have a clear recollection of the events in question. She was also fair in her answers and did not appear to be deliberately favouring the bank. I have no reason not to regard her as an honest witness, though that does not mean that all of her evidence is reliable. So that builds up a picture of people being clear, giving honest answers. We come to the defendants. During the first period of cross-examination, my overriding impression was he was reluctant to assist when faced with contemporaneous documents which suggested he had responsibility for certain matters. His typical response was that he could not remember the document. Having regard to the passage of time, 4 years or more, it can surely be said that he could not be expected to have any or any detailed recollection of many documents. Nevertheless, it was, stressing the word was, surprising that he had no recollection of some documents. For example, the elaborate instructions for dealing with offshore companies which were copied to him in May 2006, inviting his comments and which listed him as one of the persons responsible for this matter. During the second stage of his cross-examination, Mr. Z showed himself to be most reluctant to accept the indications in contemporaneous documents that he'd been involved in certain activities. This suggested to me that he was not being honest with the court. Ooh, that's not good. He was also evasive in his answers on many questions, etc., etc. It goes on. And just a couple more. Another feature of his evidence was that from time to time he would assert he was sure that he had not attended a particular meeting or had not read a particular email. It was odd that he could be so sure of what he had not done or read, given the lapse of time since the alleged non-events. When asked why he was so sure of such matters, he rarely had a convincing answer. His willingness to contradict that which was indicated by contemporaneous indications was a remarkable feature of his evidence. And then I could take you through to how it descends into sort of people talking about loans for large quantities of frozen chicken rather than oil that the bank was meant to be loaning money for. But the point of telling you all of that is that what that does with the judge is he won't believe the witnesses, which is critical. And what he will then believe are the inferences that often, that's what the claimant has. The claimant often does not have hard proof, despite all the work that all the various people have done to gather the proof. You don't have the proof because fraudsters are, as various people have said, almost by definition rather clever people, and they don't leave much of a trail despite everything. So if your witnesses, if the defendant's witnesses aren't credible, the judge can believe the inferences, and he can base his findings on the documentation and the probabilities of those documentation, and that's what happens. But I mean, and the one other thing I say about fraud trials is, and coming to this, relatively late in my career, perhaps from another sphere, and insurance always gets a bit of a kicking for being a dull area of the law. Fraud trials are incredibly dull. They're not trials where all sorts of interesting things happen. The Berezovsky-Abramovich trial, at the beginning of that, you couldn't get anywhere near the courtroom. Within sort of 2 or 3 weeks, there was, tickets for sale. I mean, it's, because you've got fraudsters who don't say anything, and you've got on the claimant side, you have a meticulous presentation of the evidence, and through document after document after document. And it may be, as I think John was saying earlier on, that in fraud cases on the claimant side, you're really trying to blow all this apart earlier on, get hold of the assets early, to take your steps against your employees, and not get actually through to the trial. But the trials do happen. Anyway, I've probably spoken for too long, but